Assalamu alaikum, good evening. Viewers, welcome to another edition of Legal Ease, where we attempt to make the law easy for you, the viewer. This evening we're going to talk about injuries in the workplace. We're going to talk about the law that covers injuries in the workplace. We've got a special guest this evening who specializes in labor law and is an expert on injuries in the workplace and the law. Our guest this evening is Zarina Walela. She's an attorney. She's been an acting judge at the Labour Court on and off several times. She chairs disciplinary hearings. She assists people at the CCMA. Zarina, assalamu alaikum and welcome to the show, and jazakallah for making yourself available.
Alaikum salam wa rahmatullahi wa barakatuh.
As you know, we're talking about injuries in the workplace, and therefore we've got you here. You are the expert. The first thing often that comes in, and we'll get into what the law is that deals with it. But firstly, maybe to kick off with, what are typical type of injuries that are experienced in the workplace? How does it happen? What's it about? Are big injuries, small injuries? Because I remember at one stage people said, even if you get a paper cut, that's an injury at the workplace, needs to be reported. So please tell us, what are the most common?
So typical injuries that occur in the workplace are when employees slip on a wet floor, for example, trip over objects lying around, being exposed to excessive noise, a typical example at the airports, and just normal, accidents occurring in the workplace. A cut or laceration is an usual injury as well.
And we know, of course, a lot of companies have first aid kits there, but I mean, we're not going to talk about that. But I suppose that's a requirement. A
first aid kit is a requirement in terms of general safety regulations in relation to occupational health and safety legislation. So there are two parts to injuries in the workplace. Firstly, an employer has to ensure that it maintains an occupationally healthy and safe environment, and when the injury occurs, then the second legislation kicks in, and that is the Compensation for Occupational Injuries and Diseases Act, commonly known as COIDA.
Oh, okay. So you're saying two acts. For somebody who doesn't know, tell us what is the main act that governs injuries in the workplace?
So in order to reduce injuries or avoid injuries or mitigate injuries, an employer should comply with an act called the Occupational Health and Safety Act. Right. And flowing from there, one gets the Compensation for Occupational Injuries and Diseases Act.
Okay. And somebody obviously is going to be liable for this. Person gets hurt in the workplace. Is the employer liable? Who pays?
So the compensation fund is a trust fund that has been established in terms of the Compensation for Occupational Injuries and Diseases Act. And that fund largely acts as an insurance so that the employer does not have to pay for any compensation arising out of an accident or disablement from such an accident. So the employer then refers this accident to the Department of Labour, and flowing from that, a claim is then lodged. And that's how that occurs.
Okay, I got a call the other day, and this is somebody who employs a domestic worker at home. And they said, my domestic worker got hurt at work, and the domestic worker says, I am liable. But surely there are some people that are excluded from the Injuries Act.
So COIDA excludes a domestic worker. Right. It also excludes anybody in military training. It excludes a member of the South African Police Service, excludes members of the South African National Defence Force. It further excludes anybody who is employed outside of the Republic for more than 12 months.
Okay, when you say employed outside, is it a South African company who employs somebody in another country?
Yes, so it would be a South African resident who
Right.
is employed in a company in another country and is continuously employed for a period of 12 months or more.
Okay, so, but if it's within the 12-month period somewhere else, then in other words, you're saying then they can
Claim.
They are covered. Okay, and there's obviously all types of things. There's procedures for lodging complaints. There's how would somebody somebody's injured on the, what's the first thing the employer must do?
So the first thing an employer has to do, Section 80 of COIDA requires that an employer registers itself as a business when it employs one or more employees. Essentially what that means is that the employer goes online, completes the forms, those forms are in prescribed format, and completes it, fills in all the necessary requirements, and the employer is then deemed to be registered and gets a registration number.
Okay, you said domestic workers, employers of domestic workers, and I presume that includes gardeners. They excluded.
It would include a gardener and
yeah.
it would include a driver employed in a domestic environment.
Okay. Small employers, somebody, corner cafe, perhaps they employ one or two people. Do they have to register?
So the obligation imposed on an employer is as soon as it employs one or more employees, the act kicks in. Right. So whether you're a small cafe owner or whether you have any 5 employee small business, you're required to register. The important part to consider in cases where there are small employers is where the Compensation Commissioner then takes into account the annual earnings of this employer and then calculates the assessment based on the annual earnings as well as the risk exposure of the occupational category. So somebody in a shop is not prone to high risk to injuries. So in that case, it probably would be a minimum tariff. The tariff is prescribed based on this calculation. So once the employer completes the return of earnings, which is a document also found online, the Compensation Commissioner then assesses the employer and an amount is then calculated in accordance with the formula that is used.
Okay, sometimes you hear horror stories. I mean, somebody would deliberately cut off a little finger because they want to claim money. But is there such, and there probably is, I mean, if there's negligence on the part of the employee, and that can be shown, will there still be a claim? Can the employee still claim?
So the obligation, whether you believe the employee or not, remains. You have to report an injury. However, an injury that lasts for, or rather the disablement that lasts for less than 3 days is not a reportable incident. And so that cuts out, excuse the pun, cuts out the person who deliberately cuts him or herself. Then the second thing is when an employee is found to be negligent, the Compensation Commissioner may repudiate the claim. In other words, reject the claim. Right. So depending on the circumstances, there are many scenarios that may arise. However, the important message out there for an employer is it doesn't matter whether you believe the employee or not. The fact of the matter is you have to register a claim, or rather report an accident, register a reportable claim, and take it from there.
Okay, we'll talk about the documentation. I got a call some time ago, and the person said, I got injured 3 years ago. Can I still claim? Does it prescribe? How much time do you have?
So an employee has 12 months within which he or she can lodge the claim, or rather the employer lodges it on behalf of the employee. There are instances when employees exposed to toxic fumes, for example, are diagnosed much later, and the rule then is in relation to prescription that once an employee is diagnosed of an occupational disease as a result of toxic fumes or noise, the hearing has been affected, then that employer or on behalf of the employee has 12 months from the date of diagnosis.
Okay, so it's not when it happened, but it's when you become aware of it.
Yes.
Okay, and if there's a late application, is there such a thing as applying for condonation like you have for other labor laws, like applying to the CCMA when you've been dismissed? If you're beyond the 30-day or the 90-day period, you can apply for condonation. Is there such a thing for injury?
No, it's 12 months and then it prescribes.
Oh, then it prescribes. So you can't, after the 12 months, come back and...
Unless there were special circumstances that, the employee assumed that the employer had lodged the claim, etc., was a registered employee, registered employer, and these things do occur in the workplace.
Okay, and what we're going to do in a little while, we're going to go on a break. When we come back, I suppose we can talk about what documentation are requirement, what must the employer put on the form to, is it required sort of medical certificates, those type of things. But appropriately, time for a break. Viewers, we're going to take a break. After the break, we'll be back talking about injuries in the workplace. And please be ready with your comments, be ready with your questions. If you have any questions for Zarina on injuries in the workplace or occupational hazards in the workplace, if you want to ask a question, if you want to lay a claim, how to go about it, or if you want to make a comment, perhaps you've got some experience, please call us. We will have the number on the screen immediately after the break. Assalamu alaikum. Welcome again. If you've just joined us, we're talking about injuries in the workplace, and our guest this evening, an expert on labor law, particularly as well injuries in the workplace, Zarina Walele, and we've been talking about the types of injuries, common injuries in the workplace, and we said after the break we're going to have the telephone number on the screen for you, the viewers. You can call in if you have any questions, if you have any comments. Please call in. We'll have the phone number on the screen in a second. There it is. It's 011-086-7777. Please call in with any of your questions. If you have any comments to make, we welcome those. You may have had some experience yourself. We've got a caller on the line. Assalamu alaikum. Hello. Caller, hello.
Assalamu alaikum.
Wa alaikum salam.
Assalamu alaikum to Appa as well. I'd like to find out if, for example, a patient only finds out about 2 years, 3 years after the condition has actually been diagnosed, that the sickness was actually related to the fumes that they were using. What does the patient do in such a case?
Okay.
And for a wonderful program.
Okay, it's one of the things we said before, that you only get to know about it 2 years later. We will answer.
So typically, a diagnosis is the trigger to the claim for an occupational disease. So the employee would lodge a complaint to the employer and communicate to the employer that I have been suffering from lung illness, or I have short of breath, and I suspect that it is the toxic fumes that I inhale in the workplace. So what an employer in that case would be obliged to do is obviously investigate the complaint, and based on the circumstances, then the employer would then report this occupational disease to the Department of Labor and obviously to the Director General Compensation Commissioner. So one cannot give a once-off answer to a question like that, because one would have to have more information. So medical reports as support documentation, circumstances and the environment that the employee is exposed to, tests. So I can't answer the question offhand, but there is an opportunity for an employee who is suffering from an occupational disease to report the matter.
Okay, we said it prescribes within 12 months, then it prescribes. This is a case where they find out 2 years later, and you did say earlier that when you find out, if that's outside of the 12-month period, you can claim. So here, person goes to the doctor sort of diagnoses and says, this was the cause of it. And the employee then realizes, oops, this happened at work, says to the doctor, this happens at work, I presume can then get the necessary medical certification from the doctor. Would that be a good start for somebody like this?
So as I've mentioned, the diagnosis would trigger the reporting of this occupational disease. And once the occupational disease is reported, the doctor will be required to complete medical reports. So one has the first medical report, and then thereafter on a monthly basis a progress medical report, and the doctor will then report on the condition, whether or not it has occurred within the workplace or arising out of the environment.
Okay, so this sometimes can take a long time.
Yes.
From the time that you put in the claim, or lodge the claim, fill in the necessary documentation, have till the time that you get your first compensation, if that's what it's
yes.
called.
Compensation does not occur automatically. Yeah. It takes a reasonably long time, and this is based on mainly the medical reports, the condition of the employee, the declaration of fitness pursuant to an accident, and then finally the last form that is completed is a resumption of work form.
Okay. And would it depend on whether the person can work, can't work? Does that make a difference?
Of course, after the employee visits a medical practitioner who is required to complete the first medical report, he or she, the medical practitioner, will indicate on that form whether the employee is fit to resume duty, and if not, by when the employee will return to work.
Okay.
So we talk about temporary disability, and we talk about a permanent disability.
Okay, viewers, just a reminder, you can call in. The phone number will be on the screen if you have any questions. Zarina, sometimes employers provide transport, either from the workplace to their homes, or from homes to the workplace, or even if the employer does contract work outside for other organizations. What happens if somebody gets injured while traveling, say, on a company combi, a company car, a company minibus, or any company transport? Or maybe the employer uses the company's motorcycle, to deliver pizzas, for example. Where does that fit in?
So an employer who provides transport free of charge, as you've just indicated, would be covered, because the test that one uses is whether the incident occurred in the course of employment. So if there's a link between the incident and the furthering the interest of an employer, and that's what we call in the course of the employment.
So it could happen that the guy delivers burgers or delivers pizzas on the motorcycle.
Most definitely, it does occur.
Because then he's still working. And the same would apply. The company provides transport from the person's home to work. Work starts at 8 o'clock, but they pick them up at 7:30 and only come to work at 8 o'clock. That half an hour before they start, the employee still...
As long as it's within the furtherance of the employer's business, i.e. I'm on my way to work, it will be covered by this act.
Okay, and then Perhaps appropriately to, back to that question of the person who got hurt or found out later, what documentation? I know we did say you need medical certification, but what else is required in terms of documents?
So the first document that is essential is, of course, the registration as an employer.
Right.
And the employees are registered in terms of that registration form. So it will include the names, the details, the salaries, the occupational category. And so there's a whole host of questions that this form has. And then the form that is also very important is a return of annual earnings, which is generally lodged about February, March of every year. And that's the calculation of the of the earnings. Then, in the event that the employee is injured, we require the notice of the report of the occupational injury or disease, and then the first medical report and further medical reports thereafter. And one then gets a claim number, and that's the beginning of that process.
Okay, one of the things you said earlier is any employer who has one or more employees must register. And there may be lots of employers, small businesses, who really don't know about this. Maybe they're hearing about it for the first time today, that they need to register. What do they do in a case like that? They've been operating for a while, nobody said anything, there hasn't been any claim. Can they go now and register, or is it going to be too late?
No, every employer, as soon as he or she becomes aware of the omission to register, is then required to go online on the website, the www.labour.gov.za, and all the necessary forms are on that website. So registration is now online.
Sorry to interrupt. Can I stop you there? We've got a caller on the line. Assalamu alaikum. Good evening. Hello.
Hello, how are you, sir?
Fine. Your question, please.
Yes, my question is about the day, like in the labor court. How long does it take to get the date?
To get a date at the labor court?
Yeah, because I did the application around April, but till now I haven't got a date.
Okay, but this is not to do with injuries at work, am I correct? This is some other labor dispute.
Yeah, it's just another labor net.
Okay, Zarina, I know you've been a sort of an acting judge, so you are able to answer it. Please, could you answer?
So the best advice I would give this viewer is to visit the Labour Court in Braamfontein if you're in Johannesburg at 20 Jutta Street, and call on the registrar's office. Obviously, you need the copy of your case number and inquire how soon you can get a date. And we all know that there is huge amounts of labour disputes. And so depending on the nature of the application or the claim that you have made, the registrar will inform you of how soon you would get a date or not.
Okay, although we're talking mainly about injuries in the workplace, and that was the idea or the purpose of tonight's program, Zarina, of course, is a labour law expert, but she does specialize in injuries, and therefore that is the main topic today. But since we've allowed one question on the labour court, if there's anybody who's got any labour questions, I'm sure Zarina would be happy to answer your questions on that. Zarina, sometimes we find an employer saying, I got hurt at work, I want to sue my employer. Can an employee sue an employer?
So Section 35 of COIDA precludes any personal liability of the employer. In other words, an employee is precluded from suing his or her employer. And the basis for that is that the mandate of the Compensation Commissioner is to provide compensation in the event of disablement. And so the Act takes the form of the insurance and claims and compensation that arise out of accidents in the workplace.
Okay. And does the Act also say, safety clothing, who's responsible for that? Does the employer have to provide that? Can the employer say, look, safety is your obligation as well as the employee? you have to provide your own safety clothing. In other words, what are the obligations of the employer? What are the obligations of the employee?
Okay. So in terms of the Occupational Health and Safety Act, there's specific regulations, one of which is called the General Safety Regulations. In terms of those regulations, protective clothing is an absolute essential in high-risk exposure. And so, in other words, at the airports, I don't know how often have you seen employees wearing earphones. And so that's basically to protect the employee against excessive noise, which may result in becoming deaf, an employee becoming deaf. Similarly, in wet areas, gumboots, masks where there is toxic fumes, goggles in the case of an employee who's a welder. So protective clothing is an absolute obligation for an employer to ensure, because occupational health and safety is both the obligation of the employer and an employee. So if the employee feels that he requires or he does his protective clothing is now broken or is lost, then that employee is obliged to inform the employer.
Okay, and appropriately, this is time for a break. Viewers, we'll take another break, and after the break, we will be back, and please stay with us. We'll continue talking about injuries in the workplace with Zarina. So if you do have any questions, any comments, please feel free to call in. Assalamu alaikum, welcome back. We are talking about injuries in the workplace. In case you've just joined us, our guest is Zarina Walele, who is an expert on labor law, and we're talking about injuries in the workplace. But we've had a caller asking about the labor code, so we have said that if you've got any question relating to labor law, Zarina will be happy to answer that. The number to call is on the screen. It's 011-086-7777. Please feel free to call in if you have any questions or any comments. We've got a caller on the line. Assalamu alaikum. Good evening. Hello. Assalamu alaikum.
Hello. Wa alaikum salam. How are you?
Alhamdulillah. Go ahead with your question.
Jazakallah. I'd like to ask Zarina that if an employee is issued with protective personal equipment, for instance, safety specs, safety boots and his clothing, helmets and everything, if the employee loses any of these items or damages his protective clothing, is the company obliged to give him another pair or replace it? Jazakallah.
So the simple answer to that is, of course, no. The employer gives the employee the first set, and importantly, then sets the rules in relation to how he or she has to look after the equipment, and in the event that there is loss or damage, that he or she will be responsible for that. So if the rules are in place, then it would be very clear in which case an employer pays and in which case an employee pays.
Okay, that's important. So the employer must put the rules in place. Employer says, these are the protective clothing that you get. You are responsible for it. I buy the first set. I buy the goggles. I buy the helmet. I buy the shoes with a sort of toe cap and, all the rest of it. You need to look after it. Once it's worn out, obviously we'll replace it. Gloves get worn out, we will replace it.
That's
but
correct.
If you lose it, if you deliberately don't look after it, you're responsible for buying it. And also, I suppose they need to tell the employees that if you don't have protective clothing, we won't allow you to work.
Most definitely. Employers who allow employees to work under dangerous conditions will be regarded as a negligent employer. It affects both the health and safety dynamic in the workplace, and it may have an impact on a claim in the event that a disablement occurs as a result of the lack of protective clothing. An employer in a similar case would be then regarded as negligent for failing to ensure that an employee has protective clothing. And the recourse that an employee has in similar circumstances, let's accept that the employee has asked the employer to replace and he hasn't, the employee then has an opportunity for an increased claim as a result of the negligence of the employer. Of course, we need to ensure, well, not every claim gives rise to compensation, so it has to be serious disablement, even cases where employees have died as a result of lack of protective clothing.
Okay, well, in the case, that is something, if an employee dies and you know, compensation, does that go to the next of kin?
So compensation in the case where an employee dies is limited to, of course, the widow, the widower, depending on who the deceased is, and then the dependents. So dependents who are wholly financially dependent on the deceased employee. And then the claim is constituted in relation to all of those dependents. The forms make provision for that, and it will be you know, incumbent on the employer in similar circumstances then to complete the form as fully as possible.
Okay, sometimes an employee is injured and it takes time, you said, before compensation is paid to that employee. Employees at home not working. Does an employee get paid? Sick leave, we know, is 6 weeks over a 3-year period. Once those 6 weeks are exhausted, does the employer have any obligation to pay that employee, to assist that employee?
So as soon as the injury or disease has been registered, a claim number has been issued, the employer becomes responsible for remuneration for a period of 3 months post the accident or the occupational disease.
Right.
The employer will be entitled to claim that, and the compensation claim is reduced by the amount of remuneration paid while the employee has been waiting. Similarly, when an employee is injured and the employer is required to transport the employee to the hospital, those transport costs are covered by the employer. If an emergency services is required to be called, those costs are covered by the employer. However, the Act makes provision for the employer then to recover those costs as soon as the claim is now payable. So the claim is then reduced by the expenses incurred by the employer. It's a huge burden on employers. However, that's what the Act requires.
Okay, a question that sometimes comes up is you have visitors to the workplace, and some workplaces we know can be hazardous. I mean, there are dangers. Obviously, people need to be careful. There are warning signs up that says, we as the employer are not responsible, be careful of injuries. But what happens if a visitor to the place gets injured? Can that person claim? Is the employer liable in some way? Where does that person?
So the Compensation for Occupational Injuries and Diseases Act only covers an employee employed by an employer in a business and who has been injured or has sustained contracted a disease arising out of the employment. So when a third party enters your employment, and given that your occupational health and safety regime is in place, then that claim does not lie against COIDA. That claim lies against public liability that the occupier of the premises may have.
Okay, so that wouldn't be covered.
So that's a different insurance.
And if the person is an independent contractor and not an employee?
Similarly, the same rule applies. The emphasis is on the employer-employee relationship.
Okay. We touched on procedure. We've spoken about what is required to fill in the form, but we said we're going to go into the details of what forms need to be filled in, what the employer need to include with those forms, what does the employee have to bring to those forms. We touched on medical certification, those type of things. Is there a specific procedure, special forms that need to be filled in? How must that be done?
So on the website, relative to this legislation, one would find all the necessary forms. So the first form is the notice of the accident or the occupational disease. That gets completed, sent off to the Compensation Commissioner as soon as the accident has occurred, before the end of that shift, and reported within 7 days to the Compensation Commissioner. Once that form is completed and the Department of Labour or the Compensation Commissioner has accepted the claim, numbers issued. And the form that then is filled in, that form is a CI2 form. The next form is the medical report that goes off to the Compensation Commissioner, and follow up medical reports. Thereafter, there aren't other forms other than medical reports. So in the notice of the accident, there's sufficient room in that form to highlight how the accident occurred, what were the main causes of the accident, if any. It may also become necessary for the Department of Labour to send an inspector to inspect the environment and then to confirm the information that was entered onto these forms. And so, cautionary note, there's always comebacks if the information is not correct, and the Compensation Commissioner suspects that there is something untoward, that will generally be exposed through an investigation, and the employer will be fined.
Okay. It's time for a break. After the break, we can talk a bit more about what happens if an employee isn't registered, an employer gets injured, and that employee now goes to the Department of Labour and claims. But all that till after the break. Viewers, time for a break again, and please stay with us, join us after the break. We will continue with this discussion, inshallah. Assalamu alaikum, good evening again. Welcome if you've just joined us. We're talking about injuries in the workplace. Our guest, Zarina Walele, who's an expert on labor law, also specializing in injuries in the workplace. And just a reminder, the phone number is on the screen. If you have any questions, if you have any comments, please call 011-086-7777. Zarina, just before the break, we said when we come back, we're going to talk about what happens if an employer is not registered. Employee gets hurt, employee goes to the Department of Labor because somebody says to the employee, you can claim compensation because you were hurt at work. How is that going to happen, and what will be the responsibility and obligation of that employer?
Yeah. So firstly, the fact that an employer is not registered is not a bar to claim.
Okay.
So the employer has a reason to explain to the Department of Labor why he or she has not registered. However, the Department of Labor or the call centers at the Department of Labor would assist an employer. So the Department of Labor is encouraging employers to register, and that is specifically aimed at to ensure that the insurance fund, this trust fund created by the COIDA, is financially able to assist employees who have been injured. So the chances that the Department of Labor would be punitive are slim. The Department of Labor has a discretion in how it wants to deal with similar incidences. Any employer who's faced with a situation like that, I would advise to strongly you know, disclose and then register as if.
Okay, so it's possible there could be a penalty, but you're saying it's unlikely. The Department of Labour will usually overlook it. They'll just be too happy that the person is now registered and will be contributing towards the fund.
So potential charges that would accrue to an employee who is not registered would be interests on annual returns. So for a period, at this stage, I think they require a period of 4 years of old annual returns. So they will backdate your returns. They will do an assessment. You will be required to pay that those 4 years, and of course the year in which the incident has occurred. Over and above interest, there may be penalties or fines, but if the employer, you know, explains and discloses circumstances, there is a possibility that that discretion would be exercised by the Department of Labour.
So therefore it's important that employers do register, because if they don't register, they could sort of sit with sort of back pay for 4 years. That's what you're saying.
Yes. So employers think they can get away with it. They only get away with it as long as there's no injuries in the workplace.
Okay, we've got a call on the line. Assalamu alaikum, good evening. Go ahead with your question. Hello, assalamu alaikum. Yeah. Hello. If you put off your TV, you'll be able to do this a lot better. Okay, we've got another call on the line. Assalamu alaikum. Hello, good evening. Okay, that call has gone off. We had a call on the line, they sort of went offline again. But there may be a problem with the line. So if not registered, it is important that people do register, because if there is an injury, they could sit with sort of a huge bill because they haven't paid for a few years. Okay. Often, I mean, when we talk about UIF, people say, how much can I claim? When somebody gets injured, how much can they claim?
So the amount of compensation is prescribed. So a person who's permanently disabled, in terms of the schedule to the Act, would be informed about the amount that he or she may claim or be entitled to claim. So it's...
Okay, we've got the caller back on the line. Assalamu alaikum, good evening.
Hi, can you hear me?
Yes, we can hear you now.
My name is Jeff, and I'm wondering if you could help me.
Okay.
I had a mine accident with a large mining group in 2008, and they said to me my left foot would come right, but it's lame after 2 years, but it never came right, and it's dead. And I can't use my, I can walk, but it's dead, and I kicked my foot on the corner of the house, and because I had no feeling, I didn't know that I broke the toes. Now they don't want to reopen my file, and they have got it on file. How do I get that file? And is it best to go see a lawyer, or is it best that I go and see this company?
Okay, so before you answer that, you can listen on the air. We've got another caller, and then Zarina will answer both questions. Is the other... Okay, we've dropped the other caller. Zarina, go ahead and...
So if I understand you correctly, it appears that your claim is now repudiated, or rather that they don't want to open your file. There is an opportunity for you to lodge an objection against the repudiation. This will generally then go to an appeals committee, and based on the outcome of the appeals committee, you would know which route to go. I suggest that you do consult with somebody and get proper advices. I find that the call center or the labor centers in every province is quite user-friendly. People are helped at those centers. So if you're not able to afford legal assistance, then I suggest that you do go to the labor center. There are forms that you are required to complete for the objection. for the repudiation of the claim. So I suggest also that you go and see your specialist, medical practitioner, who would then assess to what extent the injury has now continued, and that you would that claim should not be repudiated, and that would be your supporting documentation in similar circumstances.
Okay, I think the caller's not with us anymore. Okay, we were talking about when the caller called in, and maybe let's just revisit this a bit in terms of how it is calculated. You were talking about it, and of course then we had the caller. How are claims calculated?
So as I've indicated, claims are prescribed. So for example, if you've lost a finger, there's a percentage of your annual earnings that you would be entitled to claim. If you lost your arm at shoulder level, there would be a certain amount. So there's no magic figure and there's no lotto waiting out there. It's largely dependent on the schedule attached to the COIDA, which stipulates the amount that you can claim, or rather the sum total that you may claim in a specific circumstance.
Okay, so it's not it doesn't matter what the injury is. I mean, it's injury specific, that's what you're saying?
Yes.
It's not just somebody's hurt, they can't work, so they get an X amount.
So it's a loss of a finger, loss of a limb, loss of hearing, loss of speech, eyesight, one eye, both eyes. So,
and I suppose that's based on whether the person will be able to use that again, whether the person will be able to work again, and for how long can a person claim? Or is it a fixed amount? Is it a monthly amount? Can the person go on claiming for years and years?
So generally it's a fixed amount. If it's a temporary, if it's a permanent disablement, then you get a fixed amount. If it's temporary disablement, it's a period of 12 months within which you can get your monthly remuneration paid. And obviously, if it exceeds 24 months, then it's deemed to be a permanent disablement.
Okay, Zarina, let's just recap because we don't have much time left. We did say there are certain people that are excluded. For example, domestic workers are excluded. People who employ one or more employees have to register. If somebody is registered late, they could be made to back pay. We've said that independent contractors are not covered. You mentioned the military are not covered. Members of the police force are not covered. Is there anybody else that I've perhaps left out?
No, so it's domestic workers, an injury or claim, or injury that is for less sustained for less than 3 days. A person in military training, South African Police Services, South African National Defence Force, and somebody who is continuously employed outside of the Republic for a period more than 12 months.
Where would voluntary workers fit in? I mean, welfare organisation, for example.
They are not covered.
Are they not covered?
Because there's no employment relationship.
But what about the people that work permanently for the welfare organisation? They are covered.
So it must be an employer and an employee relationship. So if their voluntary worker doesn't receive any remuneration.
Okay, but the people that work there that get salaries, they will be covered.
Most definitely.
So you need to distinguish between those that do it on a voluntary basis, don't get paid, and those that actually are there and are being paid. They will be covered.
Yes, so once we've established an employment relationship, then that person is entitled to claim from COIDA.
Well, Zarina, Jazakallah for having come onto the program, and inshallah we'll call you back another time to continue with this program. I know there's a lot more. We've only introduced the program and we haven't gone into many details. Viewers, Jazakallah for being with us. And inshallah, this is the last program for this year. We will be back with you next year again to continue with Legal Ease, where we attempt to make the law as easy as possible for you, the viewers. Assalamu alaikum wa rahmatullahi wa barakatuh.